Password case from JMD item 2, second appeal 328 of 2016.
Essay number 328 of 2016. When this case was taken up in the first half, was passed over at the instance of the applicant. When the case is called up in the second half, nobody is appealing on behalf of the parties. This appeal is dismissed for non-prosecution.
Item 4, second appeal 274 of 2017.
फाइल दीजिए
Delhi 2 में to conduct serial number 2
तो जो डिसमिस कर दिए हैं
Delhi.
इनका अपीयरेंस या आप तो नहीं थे जब डिसमिस किया
आज जब तक
कोई बात नहीं
अपीयरेंस दे देते
नहीं दे सकते हैं बस ये सब रिकॉर्डेड प्रोसीडिंग है ना ऑर्डर डिक्टेट किए आपके
पहुँचते
एब्सेंस
पहुँचते
इसमें कौन है इसको भी डिसमिस कर देंगे आप हैं इसमें अदर साइड चलिए खोलिए फाइल खोलिए ओपन योर फाइल
My senior at Readiness is in court number 6 on this.
I will not adjourn it. I will not adjourn it. So you're for the respondent.
This one.
Your senior has asked not to read the file. Yes. Where is your file?
File is there
There.
at the back. I have just came in.
Appellant is not there. We'll dismiss the case. Why should we bother? Specific Relief Act Section 16(3) का इतना छोटा सा issue बना हुआ है. A useless case है. और after 11 years. Where is he? Appellant is absent. Counsel for the respondent is present. In order to give one more chance to the appellant, post dismiss tomorrow. कल तो पक्का dismiss कर देंगे. चलिए, next case. क्या हुआ? कौन सा serial number? 2 तो DFD हो गया. ये मतलब क्या आपका पास ओवर हुआ था? ऐसा मत बोलिए कि आप थे. उठते उठते तो हम मना कर दिए थे ना कि हम नहीं अटेंड करेंगे.
अभी हुआ है
अभी तो वही तो इसीलिए आप
इसको सुन लिया जाए हम तो
अदर साइड है चलिए तैयार है लाइन फाइल बताइए क्या सब्सटेंशियल क्वेश्चन ऑफ लॉ बना है
substantial question of law whether the concurrent findings of both the court plus suffer from falsity due to new consideration of the issues involved in this case on the basis of evidence oral and documentary adduced by the parties.
इसका क्या मतलब हुआ ये कौन सा सब्सटेंशियल क्वेश्चन है आप बताइए किस इशू की बात इसमें कर रहे हैं इश्यूज मतलब ऑल द इश्यूज
Issues have been framed of the defendants whether the defendants are right or not. That has been framed by the learned trial without having any counterclaim. And some of the issues have not been decided.
The trial court.
The trial court.
Let me just see.
Yes.
Plaintiff का क्या केस?
हाँ plaintiff का केस है.
आप plaintiff है ना?
हाँ plaintiff.
आपका क्या केस था बताइए?
Plaintiffs have sought. There are two sets of plaintiff. First set of plaintiff and second set of plaintiff. And the
plaintiff तो एक ही सेट होता है ना? Plaintiff दो सेट कैसे होगा?
plaintiff में दो सेट में मतलब ये plaintiff का क्लेम जो है शेड्यूल बी और सी और उसी के लेकर शेड्यूल ए बना हुआ है जो शेड्यूल ए सूट क्लेम है.
Just a moment. All the plaintiffs must have filed the same for the same relief. ये दोनों अलग-अलग हैं.
नहीं for the same thing. For recovery of right title possession and confirmation of possession and alternatively for recovery of possession.
बताइए.
This is the case of the plaintiff in nutshell in that the ancestor of the plaintiffs were assessed with the rent relating to the plot number 78, 73 and 96 and plot number 97 was also assessed and similar position is that the plaintiff number 3 the second set has also reclaimed the land and rent was also assessed in demand was. And the proceeding under section 144 CRPC was initiated, and that was vacated against the plaintiff, present plaintiff number 1. Thereafter, the proceeding under section 145 CRPC was initiated, and in which the position of the defendants has been declared, and in revision that has also not been interfered with. So the plaintiff has filed this suit. And the necessity for filing the suit, since the order under section 145 CRPC that has cast cloud on the title and possession of the plaintiffs, and thereafter the plaintiffs have filed the suit for declaration of right title and confirmation of possession alternatively for recovery of possession.
Just a moment. Let me see your claims and written statement.
Plaintiff. Plaintiff.
Correct. Plaintiff.
May I read the plaintiff?
ट्रायल कोर्ट का जजमेंट से पढ़ लीजिए।
ट्रायल कोर्ट के जजमेंट से
आप कौन?
यही है।
देखिए ये सब नहीं चलेगा मिस्टर शर्मा, प्लीज डू नॉट इंटरप्ट। Which matter? Ready मतलब I am not ready in the next matter. आपको लगता है एक मैटर दूसरे से कनेक्टेड?
आइटम नंबर 3
कौन सा आइटम नंबर 3?
इसके
जस्ट बात
जस्ट बाद वाला तो आप लोग दोनों नहीं थे तो हम उसको एडजर्न कर दिए, कल के लिए कर दिए। 16C वाला ना आइटम 3 का
3 4
ये तो पासवर्ड
इनको पता ही नहीं है कौन सा।
4 आई एम रेडी।
आइटम 4 टुमारो हुआ है क्योंकि कोई नहीं था, हम तो डिसमिस पर डिफॉल्ट नहीं किए, कर देना चाहिए था। आप किसकी तरफ से हैं? अपीलेंट है तो हम कल के लिए करते हैं।
इसमें तो अंदर अभी नहीं मिल पाया था।
नहीं इसका क्या मतलब है? व्हाट इज दिस?
तो ये
आपको फाइल नहीं मिल पाया,
ये बात
आपको ये नहीं मिल पाया, इसका क्या
ये भी
मतलब है?
आपको
हम इस केस को डिसमिस पर डिफॉल्ट कर दिए थे, ठीक है? आई एम जस्ट टेलिंग यू, इस केस को मैंने डीएफडी कर दिया था,
इसको
इसी केस को।
आई कैम लेट।
ही केम लेट, हाँ मैंने डिसमिस पर डिफॉल्ट कर दिया था, फिर आपके काउंसिल से कंसेंट लेकर इस केस की सुनवाई शुरू करी। अब आप बीच में आके बोल रहे हैं कि आप एंगेज्ड हैं, आपको फाइल नहीं मिला है,
जो सच है तो
क्या हम
जो
समझेंगे?
सच है तो हम बता रहे हैं। नेक्स्ट 4 नंबर में हम आई विल से इन द मॉर्निंग सेशन आल्सो आई एम रेडी। आई विल बट सो फार एज दिस मैटर यू आर नॉट
On the day of
आपके केस में अदर साइड कौन है? यू आर देयर,
someone from my office that he was present.
कॉल हिम।
That's Mr. Krishna will argue the matter. I will assist him.
सो क्या करें हम? इंद्रजीत सिन्हा के पास
No,
चले
we are
जाएं?
ready. We are ready with you.
तो यू आर रेडी, यू आर्ग्यू।
We are for the respondent. Yeah.
ये सर काउंसिल का भाई आपके सीनियर दूसरे कोर्ट में है,
No,
तो
see,
हम
we
तो
will
नहीं
come.
जा सकते ना
We will
उनके
come.
पास।
We are for the respondents. We are ready with you.
ठीक है। तो क्या करें हम बताइए?
इसको हम लोग कल पर रखते हैं। ये वाला 4 नंबर वाला सुन
आपको भी टाइम चाहिए है ना?
हम तो रेडी ही हैं, ऐसा नहीं रेडी हैं, आई एम रेडी टू बी। दो आई कैम लेट। A substantial question of law was framed in his presence. Mr. Sharma sir on that very did appear in file order dated 27/9/2023. Thank you.
With the consent of the learned counsel for the parties post this case on next Thursday. It is made clear that no adjournment will be granted on the next date. Counsel for the parties are directed to prepare short synopsis
Yes.
in connection with the substantial question of law which have been framed in this case, and also furnish supporting judgments, if any.
Yes, yes.
The needful will be done latest by Tuesday. आपका सीरियल नंबर 4 है? चलिए कॉल कर लीजिए.
Item 4, second amendment 274 of 2017.
Yes, please. Date of agreement, Mr. Sharma. You are the
And the appellant,
We have prepared a short minutes fact sheet.
they were plaintiffs.
plaintiff appellant.
Plaintiff appellant. Plaintiff
Suit for
appellant.
specific performance.
Yes.
Date of agreement.
Date of agreement should be 31/1994. 31/1994. It is exhibit 4.
30
Yes,
31/1994.
94.
Exhibit.
Exhibit
Exhibit
4.
4. Consideration
Total consideration was 75,000.
75. As per the agreement, how much was paid?
It was 7 katha, 3 and
How much was paid as per the agreement?
as per the agreement, it was 25,000 at the time of the agreement.
35,000 paid at the time of agreement.
And there are two parties. First one, to the agreement, my lord will find that first is the plaintiff, which is the appellant number 1. And another one, your lordship, is one Asha. My lord, at the time of agreement,
Plaintiff and Asha Devi.
they entered into an agreement with the defendant. For
With defendant number? Sole
Yes,
defendant.
sole defendant. So
With defendant. What was the timeline?
no,
Timeline.
there was no time.
Any condition? Any condition in the
Condition
agreement?
was that जब ये करा लेंगे परमिशन करा लेंगे तो
Which is that clause?
ये अब लिखितधारी के नाम से बिक्री करा कर रजिस्टर करते हैं. बस परमिशन कोई कारण से परमिशन नहीं मंजूर हुआ होगा तो वैसी हालत में लिखितधारी असर विद्या क्या जाना लिखितधारी को वापस करें.
Then what happened?
Then my lord, subsequently my lord, the husband of the
Why two persons were there? The property was in whose name?
property was in the name of the defendant.
Sorry?
Defendant.
Okay.
Defendant entered into an agreement with these two
That's
persons.
right.
One is the
Why two persons? It was to be jointly purchased by plaintiff.
Jointly
and they have entered two persons had entered jointly for two portions of the land.
Two portions.
The first I was intending 5 katha 3.5 chata, or the other Asha Devi was 2 katha. My lord, may kindly see the very recited itself.
You were claiming how much?
5 katha 3.5 chata.
Meena Devi. Who is Meena Devi?
Defendants. Whether Meena Devi is the plaintiff.
Plaintiffs. So it was Meena Devi and Asha Devi.
Meena Devi and Asha. They entered into an
Meena
agreement with
Devi.
Brahmlata party.
Asha Devi is not aggrieved.
My lord, then what happened? Your Lordship? That so far as the Asa Devi, Your Lordship, is concerned, the case of the plaintiff, that she turned his mind. Then another one, Sonia Devi, Your Lordship, she entered into steps, into her steps, my lord, and she is the plaintiff. My lord.
Now plaintiffs are
Meena and Sonia.
Meena Devi and
Sonia.
any fresh agreement?
No, don't. Then Your Lordship, suit my lord proceeded, and the trial court, my lord, dismissed this. The grounds.
Where are the issues framed by the trial court?
No.
Internal page number 5, Lord Choice.
Which of the issues are you agreed with? You are agreed with which issue?
One was the maintainability that. My lord,
That has
let
been
me-
decided
let-
against
let-
you?
Let me, my lord, let the substantial question of law which my lord has framed subsequently. My lord, may kindly see 12th of June 2020. Earlier there was only one substantial question of law. It was framed on 8th November 2019. Then Your Lordship had, at our instance, my lord has framed these three substantial questions. Further three substantial.
Can you read it?
My lord, yes.
Can you read it?
Para 6, Your Lordship, may kindly. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, the following additional substantial question form for consideration. Whether learned appellate court, while passing into judgment and legally committed perversity in holding that there is no concluded and valid agreement, the text Peace Act 1994 the bill for between the plaintiff and defendant, despite holding that plaintiff number 1 contributed payment of 19,000 on 13/1/1994, 15,000 on 14th March 1994, and 5,000 on 11th December 1994 through her husband Harvinder Vishwarma, PWA, to the defendant and directing the defendant to return the aforesaid amount to plaintiff number 1 along with an interest of 12% with effect from 11/12/1990. That is the first substantial question. Lord, in this particular case,
Next.
Lord, the appellant before Your Lordship is the Meena. And the learned trial court has directed to return that much of amount
To Meena Devi.
appellate to Meena. Our case, Your Lordship, is that we have
Refund of money.
as such no relief is there. But this relief has been granted to the other.
And they are not agreed by that.
We want a specific.
D.
We, Your Lordship, whether the finding of the learned appellate court that Exhibit 4 is not validly concluded agreement between plaintiff 1 and 1 Asa Devi, and defendant number 2 and group number 5 not being the party to the agreement. The suit for a specific performance was not maintainable. The plaintiff has no valid cause of action is nothing but negligence. Whether the Asa Devi was a necessary party to this, whether the agreement is severable in nature and could be subject matter of a specific performance of contract only with respect to Meena Devi in exclusion of the Asa. This is what is the substantial question. At the very outset, Mulad, I want to submit that Mulad, two persons, one Meena Devi, who is the plaintiff, appellant before your lordship. And another Lord, one Asad, they entered into an agreement with Premlata. Lord, from
Meena
the recital
Devi,
of
just a moment, and Asha Devi.
yes,
Agreement with
agreement with Premlata party.
Premlata,
Defendant. Madam,
Premlata,
Prem.
defendant.
Yes. Further case of the plaintiffs, your lordship, Asha Devi, your lordship, changed her mind. And then, my lord, in her place, my lord, it is the Sonia Devi, my lord, it has also come in evidence, my lord, and in complaint also, that the consideration money of 16,000, which was paid to Premlata Pandey, my lord, that was returned by the Sonia. This is what
No,
we
I
do.
don't get it. Asha Devi changed her mind.
Change.
And then
the
Premlata
senior-
refunded that amount.
No, that amount was refunded to Asha Devi by the Sonia Devi. Meaning thereby she substituted herself in place of Asha.
And
Thereafter, my lord,
just a
find-
moment.
Yes.
How much was the amount paid by Asha Devi?
16. At the time of the agreement,
16,000.
Total was 35, out of which I paid 19.
With consent of Premlata? With consent of Premlata?
Yes.
Premlata
What is our
was-
case? That our case.
With consent of Premlata. Premlata has been examined?
No, not it.
Premlata is the defendant.
But she did not even appear. Neither any evidence on their behalf.
It was ex parte.
Appeared but did not give any evidence.
Written statement must have been
Clean
filed.
statement was filed.
Written statement. Written statement.
But no evidence.
No.
No evidence, no cross examination. They did not participate also. भाई आपको नहीं पता मिस्टर शर्मा तो फिर आप क्या फाइल पढ़े
नहीं
हैं?
हम पढ़े
लग तो नहीं रहा हमको.
नहीं हम पढ़े
आपको यही नहीं पता है.
नहीं हम पढ़े
हर चीज में उनसे पूछ रहे हैं अपियर हुए नहीं हुए एविडेंस दिए नहीं दिए तो बेसिक चीज है.
पढ़े
WS filed but no evidence.
No.
Did she participate?
Lordship, she
Cross-examined?
cross-examination was done.
देखिए, the learned counsel for the appellant has submitted that the agreement of sale dated date बताइए please. Agreement of sale
30th January 1994. Lordships.
dated 30th January 1994. Yes, agreement of sale dated 30th January 1994 within bracket Exhibit 4 for a total consideration of rupees 75,000 was entered into between Meena Devi and Asha Devi on one part and the defendant, namely Premlata Pandey, on the other. Meena Devi and Asha Devi had two distinct portions of the property,
as depicted in the second.
and the consideration amount with respect to both of them were also different.
No, my lord.
That
It
is
was
not
not
separately
mentioned.
mentioned.
Okay, sir. Okay. Had two distinct portions of the property. Just a moment. He submits that in the that Asha Devi opted out of the agreement in as much as she, in as much as Sonia Devi came in her place, and Sonia Devi paid the entire consideration amount already. Sonia Devi paid the consideration amount paid by Asa Devi to
Premlata.
to Premlata directly to Asha Devi, and consequently the monetary part between Asha Devi and Premlata was taken care of. यही है आपका केस?
Consideration was paid by the Sonia.
Yes. The learned counsel has submitted that ultimately the suit for specific performance of contract was filed by Meena Devi and Sonia Devi.
Yes. And one more fact your Lordship will mention.
And admittedly no fresh agreement was entered into.
One more fact your Lordship will mention. Exhibit 2 your Lordship will there is a document on record which is in the name of, which is a permission document, which is in the name of Sonia Devi and the
The learned counsel has submitted that so far as the required permission for transfer is concerned,
application was made in the
the application by Premlata Pandey was made in the name of for selling the property in the name of Meena Devi and
Sonia.
Sonia Devi, which itself goes to show that Sonia Devi was in picture with consent of Premlata
Yeah.
Pandey.
Some additional facts your Lordship is also essential but to bring to notice of this. Lord, after entering into the agreement, this Meena Devi, my Lord, she constructed a house and she is residing there. My Lord, the Premlata Pandey, she filed a my Lord, eviction suit against the defendant's husband, against the husband of the plaintiff, Ravinder Vishwakarma, which has been dismissed. We have brought those my Lord, eviction suit decree and judgment. Nature of the pleadings were from the terms.
It was exhibited.
It was dismissed.
It was exhibited.
It is exhibited.
Suit for eviction.
Suit for eviction.
On what ground? Title suit.
No, it was for default in payment. Exhibit 5 Malak and Exhibit 6.
Exhibit 5 is the suit dismissal. What is the title? What is the eviction suit?
34 of 2003.
34 of
2003.
2003. Exhibit 5 is dated
Exhibit 5 your Lordship is dated 20th February 2010.
22/2010, and Exhibit 6 is the appellate order.
No, it is decree.
Exhibit 6 is a decree. The learned counsel has submitted that Meena Devi had constructed a house over the portion of the property which was to her share as per the agreement, and Premlata Pandey had filed eviction suit on account of default in payment of rent against Meena Devi, which was title eviction suit number 34 of 2003. The same was dismissed by the Exhibit 5 by judgment dated 22/2010, Exhibit 5, and the corresponding decree is Exhibit 6. Yes?
Yes. my lord, yes, I wanted to, my lord, brought to notice of this court, your worship, that, my lord, this eviction suit, my lord, that is suit number 34 of 2003. The entire, my lord, the pleadings, etc. are seen. And my lord, though the last portion of the judgment, my lord, the title, landlord-tenant relationship is written, but from the fair portion, it is a degree of eviction again from premises, further to put the plaintiff in actual position on the cost of this. This was the relief sum.
No, whatever with the relief,
But
we are
the-
not
but
bothered
the
about it.
eviction-
In an eviction
eviction-
suit
eviction.
under BBC Act,
Yes.
so we just, it has got not much of importance. Yes, continue.
Yes, the learned judge had concluded that there is no landlord-tenant relationship, so it will be an eviction suit. But the nature of pleadings are almost same. What is our stand here? That was the stand here. Then, my lord, learned trial court, your worship, it dismissed this on the grounds that suit was not maintainable and the agreement itself was also questioned. Validity was questioned.
On what ground? On what ground it was questioned?
As per the validity, both the courts, your worship, it is not a concluded contract. It has been clarified by the appellate court, your worship, that there is no concluded contract. So I would like to little pause, my lord, here. My lord, so far as, my lord, the
Is
Sonia
it,
Devi,
is
your
it
worship, is-
your argument that it is not a concluded contract, and if you want to challenge that, is it a part of any of the substantial question of law?
Yes, that is the first substantial question of law which has been framed.
Achha, no conclusion. Okay,
My
fine.
lord, so far as the concluded contract with the worship is concerned, with the Sonia Devi, your worship, Sonia Devi, your worship. Right now, I am not concerned because the appellant which the appellant before your lordship is Meena Devi. My lord, if my lord hold tomorrow, my lord, that there is no concluded contract between my lord the Asa Devi, Sonia Devi and the Prem Lata Pandey on account of the fact that she is not the agreement, not in the agreement itself. That is not the case with the plaintiff. Plaintiff entered into an agreement and my lord, she paid.
You see, Sonia Devi was a party to the proceedings.
Yes.
There is a concluded finding that it is not a concluded contract.
What I am submitting.
Therefore,
Yes.
if there is a finding that it is not a concluded contract, it becomes final against Sonia Devi. She is not the appellant before us.
To that only, but I have, my lord, argued, and my lord has framed the substantial question. Your lordship may kindly see, my lord, substantial question number D. Whether the agreement is severable and in nature.
We have seen your concludes.
Yes.
Now you tell us. You can argue the case issue-wise.
No.
Please argue your case issue-wise.
Yes.
Pick up one substantial question of law, complete your argument
Yes.
on that, and then shift to another substantial question of law. We know the concludes now.
Yes. So far as the first substantial
Which
question.
one are you want to address first?
First.
Which one?
Which
A,
one?
6A.
A. The first substantial question of law, I want to argue.
One issue which is my submission. The suit has been held to be barred by limitation. My learned friend will first cross that hurdle, and then other questions will follow, if at all.
There is a concluded finding on that?
Yes.
Concurrent finding?
Yes. There is
And that is not a substantial question?
no, that's
of
not
law?
a substantial question of that. That's what I'm saying.
Yes, Mr. Sharma. Cross this hurdle first. If it is barred by limitation, we will not answer any of the substantial question of law. We need not answer. Should we? It is futile, completely futile.
That I will argue.
No, you have to argue, you have to cross this hurdle first. If it is barred by limitation, the matter ends, howsoever good your case may be. Where is it?
Kindly come to page 50, running page 15, internal page judgment of the lower appellate court. First time.
Let us see.
Internal page 18. Sorry, internal page 18. Internal page 18. Lordships have come to internal page 18. Now the admitted position, last paragraph.
Internal page 18
of
of
the
the appellate court judgment.
Appellate court. Appellate court. Appellate. First appellate.
Yes.
Internal page 18. Now it is the admitted position on record that Exhibit 4 was executed by defendant on the 31/1994, but the suit for specific performance of contract has been filed on 22/3/2005 after more than 11 years. It is also admitted to the plaintiff the defendant applied for permission under section 26 of the Land Ceiling Act, and the same was granted on 22/1/99, but the plaintiff admittedly sent notice to defendant on 24/6/2004. Though it has been pleaded by the plaintiff that they requested defendant to execute sale deals with respect to the land in suit in their favor, but there is no evidence when and where plaintiffs asked the defendant to execute sale deed in their favor and offered the balance money. It is also transpires from the relief claimed by the plaintiff that after adjudication direction to the defendants to execute the sale deed in favor of the plaintiff within 3 months. Further, it transpires that one of the parties to the original agreement dated so and so, Srimati Asha Devi, has admittedly withdrawn from the alleged agreement and not interested. Under the aforesaid facts and though there is no timeline for execution of which is wrong in person to Exhibit 4, but the delay and lapses on the part of the plaintiff as well as non-participation of the other party of the agreement so and so, I find the plaintiff were not ready.
So where is the finding that what does
No, this does not say, but this is the fact. You will have to tide over it. And I have this finding words is challengeable.
This is the first substantial question of law frame.
Yes. Now, my lords,
That is the first one.
yes.
Earlier one.
So therefore, what the trial court, no one noticed is PW6, plaintiff number 6, plaintiff number 1, PW6, at paragraph 8 has said that they approached the defendant after 60 days for grant of permission. So even if grant of permission, they approach 60 days, 2 months from the order of under ULC, then also 2005 the suit is barred by time, XPSI barred by time.
No, but
there is no finding to that
there is no
effect.
finding.
But it has to be section 3 is
It
section 3 of the
was
Limitation
your
Act.
duty
Court
to
will have
get
to
it.
see.
It was your duty to get it.
No, it's not my duty. Section 3 of the Limitation. Section 3.
It can't be like this.
It was
You
framed in your
you just can't do it like this. There is a question framed. You see,
Yes.
that
So you have
is
to
the-
additionally frame this question also. Section 3 of the Limitation Act says that subject to the provisions of so and so, every suit instituted, appeal preferred, and application made after the procedure shall be dismissed, although limitation has not been set up as a defense. So the suit cannot be decreed. I am saying the suit anyways can't be decreed. It's a duty of the court. So today we are to proceed with the matter without deciding this, in my thing.
issue number 3. How was it decided by the
Yes,
trial court?
yes, I'm just coming.
How was issue number
Yes, yes,
3
I'm coming.
decided by the
Come.
trial court?
ये गलत है ना, पेज नंबर 19 कि विवाद संख्या 3 के द्वारा न्यायालय में निर्धारित करना है कि क्या वाद परिसीमा अधिनियम के प्रावधान के तहत पोषणीय है। इस वाद बिंदु के संबंध में प्रतिवादी द्वारा अपने लिखित अधिकतम के पैराग्राफ में कहा गया है वादनी का वाद परिसीमा अधिनियम से बाधित है, यद्यपि कि प्रतिवादी के द्वारा इस संबंध में कोई मौखिक या दस्तावेज साक्ष्य अभिलेख नहीं लाया, तदनुसार वाद संख्या 3 को निस्तारित किया, डिस्पोज, which is against contrary to section 3. Therefore, I think you ought to frame an additional question and decide it first. That is my request. Because on admitted facts, there is no dispute on these dates. date of execution of the agreement, date of grant of permission, and date of institution of the suit. These 3 dates are beyond any dispute. So my submission is, Your Lordship may frame an additional question and then decide the matter. Because it's a question of jurisdiction.
क्या बोलना है आपको उसके बारे में?
But my friend has every right to argue.
No, I just want to know. No, I just want to know.
Never object.
Is there any this point of limitation? Should it not be framed? The manner in which the trial court has said that defendant have not reduced any evidence and therefore it is decided.
Rightly said, they have not reduced any evidence.
What evidence?
They did not even appear.
That's right. They filed written statement.
Yeah.
They did not contest the suit.
Written a statement.
You were cross-examined.
It's just a bar
That's right. But you were cross-examined.
He has cross-examined us.
That's right. He
Yes.
has cross-examined you.
Yes.
Right. So far as the point of limitation is concerned, the court is suo motu also supposed to exercise power
I agree.
under section 3.
I agree to that purpose.
So merely because the defendant does not deduce any evidence, can any suit be allowed?
No, I don't say so. But here in this particular case, there is an agarment which there is no time. There are judgments to that effect also. I will show those judgments. That in such agarments, when there is no time is not an essence of contract. In such cases, it is the refusal part which gives the cause of action. My Lord may kindly see the Limitation Act itself.
Article 54 is 3 years from when the date fixed for performance, or if no such date is fixed, when the plaintiff has noticed that performance is refused. Paragraph 8 of plaintiff's evidence, ये कि भूबंदी के 60 दिन के समाप्त होने के बाद भी रजिस्ट्री करने में आनाकानी की प्रतिवादी तब हम एवं सोनिया देवी अपने पति के साथ उज्जवल पाल के चेंबर सो गए, फिर वकील साहब के कहने से लीगल नोटिस 24/6/2004 को दिया, वकालत नोटिस के पृष्ठ संवत सो में अपना हस्ताक्षर. They went after 60 days of expiry. What more do I know?
After 60 days of?
After 60 days of ULC permission, जब हम आनाकानी करने लगे.
तो 60 days ही तो है ना?
नहीं मैं 60 days after ULC 99 में 60 days 2 महीने बाद.
अच्छा, they gave the notice.
हाँ, no, वो मेरे पास गए जब हम आनाकानी किए, फिर 2004 में नोटिस दिए, तो फिर तो लिमिटेशन तो रिफ्यूजल तो हो ही गया. आपका पूरा स्टेटमेंट है कि आनाकानी
ना करने का मतलब रिफ्यूजल नहीं होता.
It is not open ended. It's never open ended.
Never like that. इसमें हम लोग section 3 years from when the date fixed for
सुनने
performance.
दीजिए, ऐसे नहीं करेंगे.
हाँ, आप मेरा सबमिशन है कि एक
हम आपका सबमिशन सुनेंगे.
हाँ,
लेकिन
आप
अभी इनको करने
ठीक.
दीजिए, ऐसे नहीं करेंगे.
ठीक.
ठीक. आप अपना you just argue in your own way, right? 6A. What is your submission with regard to 6A? मिस्टर शर्मा, आप इतना टाइम ले लेके नहीं कर सकते. आप एकदम कंटिन्यूअस, हम आपसे कुछ भी नहीं पूछेंगे, हम सब नोट कर रहे हैं. ठीक है, हमको पूछना होगा तो हम अपने से पूछ लेंगे. आप बस ये समझ लीजिए कि हम आपकी हर बात सुन रहे हैं और हर बात नोट कर रहे हैं. यू जस्ट कंटिन्यूअसली आर्ग्यू.
Quintessential civil lawyer I have noticed, a quintessential civil lawyer like him or my friends may not a bit on this course
Naturally,
because there is process.
there is a process.
Analytical mind is there. We are not analytical. We'll just say.
No, that is always there. That has to be there because civil law is very intricate.
Very intricate. Justice Harkoli, I'm just deviating, told me that when you draft, as a civil lawyer, when you draft a plaint or you want, you should read it, go to your rocking chair, and then think over the matter and then come back. You should never do it, just read and do it. I think that's the correct thing.
That is why I have stopped dictating many of the civil judgments in court.
It takes time.
Because it may not be so spontaneous. There are many things which may skip my mind. There are many things which may come on the way. So
It
has
is
to
true for
be.
us also.
No, that's what I'm saying.
Many things slips off our mind also.
लेकिन आप जब ये बोल दिए कि हमको नहीं पता कि रिटन स्टेटमेंट फाइल किए कि नहीं, तो हमको बहुत कंफ्यूजन हो गया।
जूनियर्स को
क्या आप पढ़े भी?
जूनियर को भी तो रेडी रहना चाहिए। They should get ready. I am preparing them.
सुनिए, उनको जितना प्रिपेयर करना है चेंबर में करिए, कोर्ट में नहीं। कोर्ट में
Everything we are not supposed to go through. They are to assist us. It's long methods, so many methods are there, and it really takes a very pain to get ready the matters.
आपको क्या लगता है क्यों नहीं सिविल में लोग आना चाहते हैं?
ये चुका नहीं।
तो मेहनत वाला चीज है, आपका डोमेन है।
They require something. That what I am saying. My friend is correct. इसमें बहुत सी चीजें बताने से पहले भी हमें भी सोचनी पड़ती है कि हम सही बता रहे हैं क्या गलत हो रहा है। Whatever you say, law, and that you on law at least, it should be absolutely correct. Actual errors are permissible. लॉ में अगर कोई एरर हो रही है तो it's our concern. Yes, I was arguing, Your Lordship, that the aggravant charge, that is 30th of January 1994, which is Exhibit 4, but when the learned appellate court, Your Lordship, had considered that payment is due to us, and before that, Your Lordship, may kindly see the exhibit itself. The agreement.
नहीं ठीक से।
The next portion I would like to show.
Exhibit
4. The agreement. I want to place agreement.
4।
Yes. The last page, Your Lordship, will like this. My Lord will find the signature of Remlata. Then Your Lordship will find there are signatures, my Lord, of witnesses. Then Your Lordship will find that that the money 15,000, 15,000 रुपए पाए, तो other things are unpaid. Then my Lord will find on 11/12/94 को धर्मेंद्र जी के द्वारा 5,000 पाए. My Lord, even the person who my Lord has died, scribe's signature is also there. So my Lord, it has all contents of an agreement. And my Lord, so far as the concluding the
All
finding
contents of it?
an agreement, Your Lordship may kindly see the
Yes,
lekhagari,
Lately.
purchasers, and my Lord, the name of the purchaser, my Lord will find. Then Your Lordship will find that who are my Lord, the purchasers, who are the sellers, and my Lord, in the purchasers portions, my Lord will find that it is very clear. It has been clarified that the plaintiff number 1, Meena Devi, Your Lordship, she wanted my Lord 5 katha and 3.5 chata. And one of the another one, Asha Devi, my Lord will find her name also. She 2 katha. So out of the total 7 katha and 3 chata, 2 persons jointly my Lord entered into an agreement. She was for the larger portion and she was for the relatively small portion. It is very much separable from the recital itself. That is the point I wanted to say. So far as my Lord,
The consideration was joint?
Madam,
The consideration was consolidated?
consideration is consolidated.
How do we sever this?
But the appellate court itself has severed. It has severed. Otherwise, no occasion for for the appellate court to ask the defendant to return 39,000. He has taken into consideration that 19,000 was paid by the Meena as per the evidence.
19,000 was paid. That has been asked to be refunded.
No, 16,000 was asked to be refunded. I am Meena Devi.
Yes.
I paid 19 plus 15,000 plus 5,000. Altogether 39,000.
You paid 39,000.
So 59,000. That has been asked to be returned.
39,000
39,000
has to be asked to be refunded to.
to the by them to me.
This is the amount you paid.
I paid. That's what
Yes,
I'm.
I'm asking you something else.
What?
From where do we get that which portion of the property would cost what? There is the consideration amount is consolidated 75,000 rupees.
Yes.
How do we know that who has to pay how much?
My lord, that would be apparent from the recital itself. My lord,
Show me, please show me that.
Yes.
That from the recital it is apparent who has to pay how much.
No, I'm what I am pointing out. The larger portion was what I was purchasing. 5 katha, 3 and 3.5 chata.
So-
And the only 2 katha she was purchasing. So, my lord, it's what natural the larger portion has to be paid by me.
Which portion? How much? What was the consideration amount qua Meena Devi and what was the consideration amount qua Asha Devi?
My lord, that is not written, I agree. But total amount was 75,000. Out of which it is written that 5 katha, 3.5 chata, I had to pay, I had to purchase, and only 2 kata was to be purchased by the one Sonia Devi later on substituted by the so Asha Devi later on substituted by Sonia. This much is very much apparent from the agreement. What is
This agreement is not severable, especially.
Lord,
Unless if there are two parties on one side in connection with the agreement claiming two distinct portion of the property, right? Even that is not segregated which portion it would be. No boundary mentioned as to who would take which portion. Who would take which portion, that boundary is also not mentioned.
yes.
Right? And apart from that, the consolidated consideration amount of rupees 75,000 has been mentioned.
But my lord,
Then how do we know? Suppose I have to pass a decree. I have to pass a decree. Which portion of the property will be sold and for how much consideration?
that has been later on substantiated in the evidence. My lord. I have constructed a house. I am in possession of the house over the property which I have purchased. And my lord, the defendant
You
has.
want to say that this agreement will be explained through oral evidences?
I'm not saying. So far as the my lord, the portion, which portion my lord is asking, the portion in which I am residing, for which she has my lord filed a suit for eviction, that has been dismissed. So those portions where I am residing, I constructed house. My lord, those portions are my portions.
You have been given the benefit of 53A. Have you been given the benefit of 53A? No.
53A I am not asking right now.
You have not been given
I'm
that
not-
benefit.
I'm not asking right now. But your Lordship, even the benefits of 53A, your Lordship, that was whether that issue or not, I'm not concerned because that suit itself has been dismissed. What I am only saying, your Lordship, that my Lord is asking where and which portion. My Lord, I constructed the property. I am in possession there. I am residing there. That is the portion, and it has come in evidence also by virtue after purchasing. My Lord,
Two things would be essential. Firstly, which portion of the property? Secondly, how much consideration?
the consideration, your Lordship.
What is the balance consideration according to you? And how do you arrive at that? What would be the balance consideration amount as per you and as per the plaint?
Yes.
Yes, tell us what is the balance consideration amount as per the plaint and how do you arrive at that?
It can be it is a mathematical, arithmetical, simple arithmetical मानो कि अगर 7 कट्ठा ले रहे हैं 7 कट्ठा आधा दूर ले रहे हैं तो अगर कट्ठा वाइज भी अगर हम कैलकुलेट करेंगे तो what will be the price for 1 कट्ठा? It can be calculated. Naturally, a person purchasing 5 कट्ठा, he will pay that much of consideration. And my lord, if somebody is taking only 2 katha, that katha can be calculated, my lord, arithmetically. These things are always several. So far as, my lord, the degree part of the
Let us take it. No boundary with respect to each in the agreement. Right?
No boundary is there. Boundary is there. Separate boundary is not there, but the boundary.
That's right. Separate boundary. I'm talking about separate boundary.
But here, even if
Then, just a moment. No segregation of consideration amount. And no timeline. These things are important features. From the perusal of exhibit during the course of argument, exhibit 4 has been placed.
From the agreement, Lordship, it would not transpire that the possession was given to the plaintiff pursuant to this agreement. There is no mention that the possession will be handed over to the plaintiff pursuant to this agreement.
With respect to the agreement, exhibit 4, the learned counsel for the appellant as well as the respondents have placed the agreement, and it is not in dispute that as per the agreement, though the entire boundary with respect to the property to be sold to Meena Devi and Asha Devi, totaling 7 3/2, 7 kattha and 3/2 chhatak has been mentioned, but separate boundary with respect to each one of them has not been mentioned. Further, there is no, though the total consideration amount of rupees 75,000 has been mentioned, but it has not been mentioned as to who would pay how much amount out of total of rupees 75,000. And further, the agreement does not have a timeline as to after how much time the sale deed would be executed. The counsel for the respondent has also submitted that there is no mention in the agreement that pursuant to the agreement, the possession of the property has been handed over to the applicant.
I have specifically stated in para 12 of my claim that the plaintiff number 1 constructed temporary residential house over portion. The house consisting of 2 rooms, 1 kitchen, veranda, latrine. Construction is worth of rupees 80,000 and she is residing since the construction which was constructed in the year 1994 after just execution of the act. My pleadings are very specific. Lord, may kindly see.
The learned counsel for the appellant has referred to paragraph 12 of the plaint to submit that it has been stated therein that the appellant immediately after the execution of agreement has constructed a temporary construction
Yes.
over the property which she occupied immediately after the agreement.
Yes, in reply, my lord, they have stated in the written statement that the statements made in para 12 of the plaint are false. House was constructed by this district and
By the defendant.
defendant and was let out to husband, which has been proved false.
The learned counsel has submitted that in response to this statement, the defendant had made a statement that the house was constructed by the defendant and it was let out to the appellant, but in the title eviction suit number 34 of 2003, the eviction suit has been dismissed.
Not as far as it is 54,000 and altogether was to be 45,000, 3.5. Out of which 59,000 I got.
the learned counsel further submits that as per the plaint,
As per us,
As per the calculation.
calculation.
as per the plaint,
No.
plaint में होगा ना
Plaint में
remaining
नहीं है।
consideration
As
amount.
per the calculation.
आपके कैलकुलेशन से क्या होगा?
हजूर
प्लेट में बोलना पड़ेगा ना वो.
पूछा है तो
भाई पूछने से क्या है? ऐसे
नहीं,
नहीं
ये
हो
वाला
सकता.
जो-
No,
जो
it has to be
question
there in the plaint that
ये
this
वाला
is
जो
the remaining consideration amount and this much of amount I have to pay.
that is
During the course of argument, the learned counsel for the appellant has submitted that the balance consideration amount to be paid by the appellant has not been mentioned in the plaint. However, upon his own calculation, he has stated that 54,000 would come. 54,000 would come upon arithmetical calculation, and out of which 39,000 was already paid. आपने कितना ऑफर किया? भाई रिमेनिंग बैलेंस कंसिडरेशन आपने कितना ऑफर किया उनको? कुछ नहीं.
एविडेंस भी तो आया है कि बैलेंस बोल रहे हैं।
बैलेंस मतलब कितना?
दोनों कर रहे हैं।
कितना बैलेंस मतलब?
दोनों कर रहे हैं।
मतलब
दोनों पार्टी जो है, वो जाते थे पैसे के लिए। फिर जो हम तो अपना प्लेस सिर्फ अपना कर रहे हैं।
ठीक.
दोनों पार्टी का ही अगर जोड़ा जाए तो वो आया है कि 55,000 हम दे चुके हैं, 20,000 बाकी था दोनों पार्टी के। दैट हैज कम। लेकिन हमारे पार्ट पर सिर्फ जो है सो 39 हम ऑलरेडी दे चुके थे और बैलेंस अमाउंट जो भी इसका बचा 39 और 140 करीब 15-16 हज़ार रुपये है इसमें हमारा देना। लेकिन तो ये चीज़ आया है कि हम 55,000 दे चुके थे टोटल सब मिला के, ये इन लोग का उसको भी 16 जोड़ा जाएगा तो अब बाकी 20,000 रुपया जो है वो एविडेंस में आया है कि 20,000 और देना चूँकि, लेकिन हम अपने पार्ट पर ही अभी ये कर रहे हैं चूँकि उनके पार्ट पर हम इसमें ये स्पेसिफिक क्वेश्चन ऑफ लॉ हम जो फ्रेम किए हैं कि इसमें सेपरेबल है कि नहीं, सेपरेबल हो सकता है कि नहीं, ऐसा कोई स्पेसिफिक परफॉर्मेंस ऑफ कॉन्ट्रैक्ट हो सकता है, इसके पॉइंट पर ये हम आ चूँकि अगर ये सोनिया देवी के साथ के लिए 1 मिनट के लिए अग्रीमेंट और कंक्लूडेड नहीं भी माने तो हमारे पार्ट पर तो ही काम किया। दिस इज व्हाट इज माय।
he submits that even if the agreement was not concluded with Sonia Devi, who had substituted Asha Devi, then also there was a concluded agreement between Meena Devi and the defendant, and therefore the same is required to be.
And the finding in this regard is absolutely purpose.
आगे. इसमें ऐड करेंगे, and therefore he submits that the finding in connection in this regard qua Meena Devi is perverse.
एक मिनट जरूर उसका हम फाइंडिंग दिखा देते हैं। Lord, may kindly see internal page 11 of the appellate court.
Right?
3 points, 4 points, my lord, was framed for its consideration. First was whether there was any concluded contract between the plaintiffs and the defendant. Second, whether the plaintiffs are ready and willing to perform their part of the contract. Whether the plaintiffs are valid cause of action, and so on. Whether the plaintiffs are entitled to relief as claimed. Point 1, Your Lordship may kindly see. My Lord, may I read one, or my Lord just?
No, yeah, I told you just continue you continue your argument. I'm
Yes.
listening to you.
It has been pleaded on behalf of the plaintiffs that the defendants propose to sell the land in the suit consideration of 75,000. Plaintiff number 1 and Asad Devi agreed to purchase the land in suit and for the said consideration. The defendant executed written agreement to sell the land in favor of plaintiff number 1 and Asad Devi after receiving 35,000 as an advance and put her signature on the written agreement dated T.24.07.2025 in presence of the witnesses. That on 14th of March 1994, said Asad Devi changed her mind and not to purchase land in the suit. She already settled with the plaintiff number 2 to purchase the land in the suit. The plaintiff and said Asad Devi also received back money advance with her property. On behalf of defendant, it has been stated that alleged agreement is fabricated. Defendant never approached on 13/1/1994. Defendant never consciously executed any agreement. Not a single file has been received by this defendant. That the plaintiff husband in good faith ordered to get the electric connection and ration card for signature of defendant and forged the deed of trust. PW4 Parbhas Chaudhary deposed that this agreement was executed by Prem Lata in favor of Meena Devi and Asad Devi. Agreement was drafted as per the direction of Prem Lata, which was typed by Ravindra Ram, a typist, and after contents of the draft were read and understood by the Prem Lata. Parbhas Chaudhary is one of the witnesses in the argument. It is relevant to point out that it is one of the witnesses in the agreement itself. And thereafter she signed before him Kedar Chaudhary, Meena Chaudhary and Asad Devi, all receiving money of 35,000. Further stated that he also signed along with Kedar Chaudhary as a witness. In his cross-examination, PW4 admitted that he was not present at the time of previous talk with the party, denied to the suggestion that no agreement was. PW5 Ravindra Ram deposed will be scribed that he knows Prem Lata Pandey, who
Mr.
always used to
Sharma,
come to the
execution of the agreement is not finished.
They are saying that
They are saying that there is no finding, no? Agreement was entered into. That is in your favor.
they are disputing it. Then Meena Devi or Ashwini kindly see PW6. PW1 deposed that she knows Prem Lata since 1993. Further stated that she used to live on rent in Chirondi with the family in the year 1993. She came to know that Prem Lata wanted to sell her land. Then he along with her husband Dharmendra Vishkarma went to the house of the Prem Lata family in Karampur. Further stated that the defendant disclosed that out of the 7 katha, 3.5 chata land, she promised to give 2 katha to Asad. Remaining 5 kathas and 3 katha is available for sale. Further, she stated that her husband asked her to give 5 katha, 3.5 chata to which the defendant agreed. PW6 further stated that she obtained address of Asad Devi from Prem Lata Pandey, and both on the same day, after paying advance amount of her husband, went to her resident and obtained agreement. Further stated that her husband paid 19,000 from her side and 16,000 was paid from the side of the Asad Devi. In this way, total 35,000 was paid in cash, and the agreement dated 31/1994 was obtained. Further stated that land involved in the agreement belonged to plot number 176, Mata number 24, Moja 106, Moja Chirondi, total area 7 katha, 3.5 chata. PW6 further stated that the execution of agreement dated 31/1994, she and her husband Dharmendra Vishkarma paid 15,000 to Prem Lata at her Karamchowdi residence. On 14th of March 1994, thereafter 5,000 was paid to Prem Lata. on 11/12/1994 regarding which two receipts have been signed by the defendant on the third page of the agreement. From the aforesaid testimony of the plaintiff number, it transpired the defendant did not make any offer to her regarding her land, and plaintiff has not accepted or given consent to any offer of sale by the defendant. Because the husband of the plaintiff which agreed to purchase on the offer given by the defendant. Further, there is no evidence given by plaintiff number 1 that any negotiation regarding the price or consideration or any proposed sale or land by the defendant which clearly transpires the aforesaid testimony of PW1. There is no negotiation of settlement at the time and the time and place and manner in the light of the exhibit. Therefore, I find there is no meetings of mind regarding the terms of the agreement between the plaintiff 1 and the defendant. It also transpires from exhibit 4 that it was drafted and typed at the court campus. And as such, per the statement, plaintiff has to take to the house of the defendant and obtain her signature. Lord, when the money is being taken, that too in after the agreement, and the signature of the vendor is already there, how can there be no meetings? This finding is totally perverse. There was a meeting of mind, the parties agreed, Your Lordship, and they entered into an agreement, and the consultation money was paid. Thereafter, there are witnesses to that effect. There is a scribe has been examined, and these vendors has taken money in furtherance of that already agreed amount. So this finding that there is no meeting of mind, there is as such no agreement, nothing like that. Your Lordship, that finding, Your Lordship, is a totally perverse finding. PW7, Your Lordship, I permitted to read. PW7 is the plaintiff number 2, who deposed in para 5 of the affidavit that she, along with her husband, went to the house of Prem Lata and paid 16,000. One woman was already sitting, who introduced by Prem Lata Pandey as Asa Devi, and also stated that 16,000 is to be returned to her. Then the money was given to Asa. Thereafter, Asa Devi went away, and she and her husband asked Prem Lata for the agreement, to which the woman of Prem Lata Pandey is not to which asked her husband for, to which Prem Lata Pandey stated there is no need. She will seek permission in her name, and thereafter the registry will be done. And my lord, the permission was taken in the name of the Sultan. This is an admitted fact. That is exhibit 2. Exhibit 4 is being reproduced. The court has not reproduced the. Thereafter, my lord, the learned appellate court, Your Lordship, has and my lord,
in the agreement, is it mentioned regarding taking permission?
हाँ उसमें तो लिखा है,
कहाँ लिखा?
ऐसा लिखा है। उपरोक्त जमीन को आज के तारीख में बिक्री करने का एग्रीमेंट किया, आप लेखाधारी के नाम से करा कर बिक्री कर देंगे ओरिजिनल पर।
उसके आगे
अगर कोई कारण बस बिक्री परमिशन मौजूद नहीं होगा तो वैसी हालत में 80 रुपया खर्चा हो जाना, कुल रुपया वही को वापस। एग्रीमेंट का बात के बाद परमिशन का बात है, और एग्जिबिट 2 में परमिशन का एप्लीकेशन में उसका नाम भी है। उसके बाद कॉन्ट्रैक्ट एक्ट का प्रोविजन वगैरह कंसिडर किए और सब चीज करने के बाद इसमें जो कंक्लूजन पार्ट पर
17, पेज नंबर 17.
चलो उससे पहले एक लाइन और पढ़ देते हैं पर एक पर ऊपर से ऑन द बेसिस ऑफ एफोर्टेड एनालिसिस।
हाँ वही
testimony of PW1 examined at PW6 and examination of exhibit 4, I find that there was no calculated existed between plaintiff number 1 and इनके बारे में भी क्या? Further, the terms of the exhibit 4 having no stipulation regarding time and place and manner pursuant to this document also makes it unenforceable because this fact is inequitable to defendant and grossly infavorability. From the aforesaid exhibit 4, original agreements as well as pleadings of plaintiff and submissions of BW6, BW1, it is clear, plaintiff number 1 clear that the agreement is quoted in the favor of Meena Devi and Srimati Asa Devi, not a party in the suit. It is further clear from the testimony of BW7 that no agreement was disputed by Premlata Pandey. Therefore, I find there is no concluded and valid agreement between defendant and plaintiff number 2. This finding may be correct. I am not agreed by it. But so far as the earlier part which I showed, that there is no concluded contract with myself, that finding is a part. Further, I find that the agreement dated 3/31/1994 for sale of entire 7.5 katha and in favor of plaintiff number 1 Meena Devi, Asha Devi. Accordingly, this point is decided against the plaintiff and in the favor of the defendant. My Lord, in this connection, Your Worship, I would like to place the operative party. My Lord, may kindly see page 20. Point para 12, Your Worship. Since the one to the party of the original agreement has not joined the plaintiff, neither has pleaded as a party in the suit. Admittedly, agreement was jointly in favor of plaintiff number 1 and Srimati Asa Devi. Entire land, as mentioned in agreement, was to be transferred in their favor, and after payment of balance considered amount, as agreed in the agreement. Plaintiff number 2 was not a party to the exhibit 4, which has been sought to be specifically enforced. Further, there is no validly concluded agreement between the parties. Therefore, I find the plaintiff have no valid cause of action and the suit is not maintainable as one. Since plaintiffs have also failed to prove their readiness and willingness, are not entitled for relief of the specific performance. However, 35,000 has been paid as an advance on 31/1994 on behalf of plaintiff number 1, out of which plaintiff admitted that she contributed 19,000. Thereafter, there are two receipts, 14,000, 14/3/1995 and receiving 15 and 5 respectively. Therefore, the defendant respondent is liable to return the amount 39,000 to the plaintiff number 1 with interest. Therefore, the defendant is directed to return the pay the 39,000 with interest from at the rate of 12% from 11.
And no amount was directed to be refunded to the plaintiff number 2?
No. Because the learned courts concluded that there is no concluded agreement. But so far as one is concerned, if the amount is being asked to return, and all these acknowledgements connect, so there was a contract, there was an agreement which one is concerned. So the finding that there was no concluded contract with respect to one unit, that is the purpose. Otherwise, there was no occasion for any refund, direction for any refund.
The learned counsel for the appellant has submitted that there was no direction to refund money to the plaintiff number 2, as the court had come to a conclusion that there was no concluded contract between the plaintiff number 2 and the defendant. But so far as plaintiff number 1 is concerned, the court has themselves, the appellate court has, the courts have themselves directed refund of rupees 39,000 to the plaintiff number 1. And this aspect of the matter itself goes to show that there was a concluded contract between the parties.
With plaintiff number 1 at least.
So far as the plaintiff number 1 is concerned. ठीक है? और कुछ?
So far as B is concerned, whether the finding of the learned appellate court that exhibit 4 is not a concluded agreement between plaintiff number 1 and 1 Asha Devi, and defendant and plaintiff number 2 not being a party to the agreement, suit for a specific performance was not maintainable, and the plaintiffs had no valid cause of action in backing the party. My lord, the court, learned appellate court has also said that the suit itself was not. My lord, when there is a contract with my lord, plaintiff number 1, and my lord, there is an acknowledgement to that effect also. There is no specific timeline. And my lord, when she, my lord, always assured us, yes, I will agree, I will scrutiny the deed itself, my lord. But when, my lord, she instituted a eviction suit, my lord, against me, thereafter, my lord, we instituted this. It be prior to that, your lordship, we have sent legal notices also. That was also, my lord, not replied. Those legal notices, your lordship, have been brought on the court. My lord, may kindly so go to those annexes. My lord, may kindly see, my lord, Exhibit 3 is the advocate notice. Exhibit 3 is the advocate notice.
This particular question of law is relatable only to concluded agreement.
And maintainability part.
No, because there was no concluded agreement and therefore it was not concluded. With regard to whatever you did,
Yes.
you gave notices, etc., it is not in dispute.
No, so far, what I want to contend, let me, my lord, show what is the cause of action for the suit.
Where is it? Which is the legal notice which says that you went there for execution of statement? You asked them to execute the statement. Which is that document? And which is that exhibit?
It is an exhibited document.
Which one? Which is that exhibit?
It is two advocate notice are on the record. One is of 2002, that is exhibit 3. And my lord, another is exhibit 7.
Exhibit 3 and 7. It has been issued by them, by you.
But
Yes.
to the claim the third part. These are factual aspects of the My clientess requests you several times in the presence of witness to dispute and get the registered deed of sale in her favor, but you went on a wedding on rent protection. My clientess was all along ready and willing to, still ready and willing to meet necessary expenses towards the institution and registration of the deed of the sale, disputed and registered in your favor, but you have failed and neglected your part of the agreement and you failed to exclude the registered deed of sale in my favor of my client. Therefore, under the instructions of my clientess, give you this notice and call upon to exclusively get the registered deed sale in favor of the clientess within 50. No legal notices we have sent. And they have not responded. That's why, my lord, unless there is a refusal part, in cases, my lord, there is no timeline. Section 54 is very specific. It must
Unless even if they do not respond, you will wait for the response.
definitely, I will
Suppose they
understand.
do not respond, then you will not file the case.
I will file, but there are certain procedures.
That's right. If they do not respond to the legal notice,
No, thereafter the moment followed, because they were saying that we will issue. So, but when they issued, they filed an eviction suit, immediately thereafter we filed. By that time,
You have clearly said that you have failed to neglect, you have neglected, you have failed to execute. Everything has been mentioned.
we have mentioned.
Yes.
But
So, you
when,
see, then you gave 15 days notice, failing which you will go and file a civil suit. Right? That is there. 15 days notice.
That is there.
When does 15 days
and in
expire?
the year 2004 also we have said so.
Yes.
We have said so.
So,
Meaning thereby what I want to say, that so far as our part, your Lordship is concerned, that we took all legal steps, that part your Lordship is in order. When my lord, she did not responded, and my lord, when my lord, she filed an eviction suit, then immediately thereafter I may kindly see the plaintiff.
they did not respond in 2002, they did not respond in 2004. You could have given another notice in
I have given
2025.
2004 I have given.
2025 का भी एक नोटिस दे देंगे तो भी cause of action बन जाएगा अगर आपकी बात हम लोग मानेंगे तो
2004 में हमने दिया।
एक दिया आपने कोई रिस्पांस नहीं
2005
आया
में उसके बाद तुरंत आ गए।
नहीं मेरा यही कहना है कि फ्रेश नोटिस देने से फ्रेश कॉज ऑफ एक्शन तो नहीं बन
वो
जाएगा
नहीं कह रहे हैं, लेकिन अगर मान लीजिए हुजूर अगर somebody is agreeing, yes I will
कहाँ एग्रीइंग है आप तो बोले हैं कि 15 दिन में सूट फाइल करेंगे
10 दिन का हमने बोला, लेकिन ये जब eviction suit तब तक नहीं फाइल किए थे।
उससे क्या मतलब
Eviction
suit will not give you a cause of action
जी,
eviction suit will not give you a cause of action
but that is a real cause of action for us.
maybe
That
is not a real
till
cause of
that
action.
till that day there was no refusal as per
वो
us.
तो हम लोग देखेंगे ना
देखें, till that day there was no refusal. The refusal जब होगा तभी ना हमारा।
रिफ्यूजल इविक्शन सूट में हुआ है
नहीं, एक बार अगर आपने हमें इविक्ट कराने के लिए उस पर्टिकुलर प्रॉपर्टी पर आपने ले आया जिस पर कि हम मकान बना कर रह रहे हैं इसके पर्सुएंस में, तो देन व्हाट रिमेन्स, नेचुरली आई विल हैव टू टेक लीगल स्टेप्स, देयरआफ्टर आई हैव टेकन। माय लॉर्ड मे काइंडली सी द प्लेन।
ठीक है देख लो हो गया और कुछ बोलना है आपको बताइए
वो तो मेन क्वेश्चन बचा।
now see is whether Asha Devi was a necessary party
मतलब so far as I am concerned, I have nothing to do with this.
अच्छा
She is not a necessary party so far as our part of the contract is concerned. She may be a necessary party so far as my lord the Sonia Devi is concerned. And my lord, as because the exhibit 2 is on board, that is an exhibit document, it is a bitter document. And my lord, in her evidence also she has said that the Premlata Pandey said that there is no requirement, I will take a permission in your name. So she filed an application for permission in her name also. So far as my lord, she may be a party so far as the Sonia Devi your lordship is concerned, but so far as this plaintiff Meena Devi is concerned, my lord, she is not a necessary party. Now my lord, the last part your lordship, whether the agreement is severable in nature and could be subject matter of a specific performance of contract only with respect to Meena Devi. Plaintiff number 1 in exclusion of us.
that you have already asked
No, I am on board. Your lordship may kindly see section 12,
section 12 of
specifically.
section
Did my lord?
Just which subsection?
My lord, the law permits a specific performance of part of it. There are certain exigencies. What are those exigencies? I would like to know. Except that otherwise hereinafter provided in this section, the court shall not direct the performance of the part of contract. Normal courts may नहीं. Where a party to a contract is unable to perform the whole of his part of it, but the part which must be left unperformed bears only a small portion to the whole in value and admits the compensation in money, and the court may at the suit of the either party direct the specific performance of so much of contract as can be performed at about compensation in money for the deficiency. Where a party to a contract is unable to perform the whole part of it, the part which must be left unperformed either forms a considerable part of the whole, though admitting the compensation in money, or does not admit of compensation in money, he is not entitled to obtain a degree for a specific performance, but the court may, at the suit of the other party, direct the party in default to perform specifically so much of his part of contract as he can perform with the other party. In case falling under clause A, pays or has paid the agreed consideration for the whole of the contract reduced by the consideration for the part which must be left unperformed. And in case falling under the clause B, paid or has paid the consideration for the whole of the contract without any effect. In either case, relinquishes all claims to the performance of the remaining part of the contract and all rights to compensation, either of the deficiency or for the loss or the damage sustained by him through the default of the defendant. 4. When a part of a contract which by itself can and ought to be specifically performed stands on a separate and independent footing from the other part of the same contract, which cannot or ought not to be specifically performed, the court may direct the specific performance of the former part. What I want to contend with is that I showed you that the two persons were not entered into an agreement. And
that we have seen.
Yes.
So one part is not to be performed, the other part is to be.
I am covered.
With respect to the substantial question of law number 6 within bracket D,
D.
the learned counsel has submitted that the case of the appellant is squarely covered by section 12 within bracket 4 of the Specific Relief Act, and the part of the contract Toa Meena Devi is required to be performed irrespective of the fact whether Sonia Devi, who was replaced who had replaced Asha Devi, is aggrieved by the impugned judgment. Okay?
And so
और
far
बताइए
yes,
और what else?
she is not a necessary party.
That has. He submits that Asha Devi is also not a necessary party in this suit. और बताइए readiness and willingness पे क्या बोलना है?
Readiness and willingness में जो फर्स्ट क्वेश्चन उसमें हमारा कहना है कि जो there are evidence which I can show कि हम इनको जाके बराबर करते गए और इनको करते रहे।
आप जाके बराबर कहते गए हैं, पहले बताइए कब गए हैं, कौन सा एविडेंस में लिखा है कि कब गए हैं, और कौन सा एविडेंस में लिखा है कि कितना पैसा ऑफर किया। Just tell us.
बता 2 मिनट। आज और आठ
Sarah,
मीना देवी
evidence
PW6
प्लेट में कहीं लिखे हैं,
PW6
प्लेट में कहीं लिखे हैं कब कब गए हैं? There has to be a pleading also, no?
In paragraph 14 and 15, they have said the plaintiffs always ready to perform as their part of contract.
There is no
Paragraph-
specific statement in the
specific
plate. With respect to the substantial question of law framed by the order dated 8th of November 2019, the learned counsel for the appellant has
13 भी relevant है
submitted that, buddy, has submitted that though no specific date as has been mentioned as to when the
before that moment I would like to say
appellant,
para 13
just a moment, as to when the appellant had approached the defendant to show readiness and willingness to perform her part of the contract, but it has been specifically stated in paragraph 13
हम इसमें लिखे हैं that for his question of suicide defendant also applied for granting permission to say in suit under 26 of Urban Civil Act in the court of ADM branch and the same petition allowed on 22/1/1990 and in spite of permission obtained by the defendant she never showed her intention to perform her
That's
part of the contract
he has referred to paragraph 13 of the
and she always gave
Right.
assurance that the plaintiff we were in position and nobody is going to disturb. Say it will be disputed later.
that's he has referred to paragraph 13 of the plate.
और पारा 17 में हम लोग फिर बाद में ये लिखेंगे कि हमने रिटर्न नोटिस
And also referred to paragraph 17 wherein the plaintiff had stated about sending written legal notices
which was received on 1/7/2000
to the defendant
1/7/2004 को हम ये भी मेरा it has been
and
received
which was received by the defendant on 1/7/2004.
उसका हम लोग पोस्टल रिसीट्स वगैरह भी लाए all of a sudden then para 19 I was stated then all of a sudden plaintiff number 1 came to know that on 2/1/2004 the suit for eviction has already been filed by the defendant. Again, the husband of the plaintiff member, although the husband of the plaintiff member has not constructed the by the husband of the plaintiff, although construction was made by plaintiff member. Both plaintiff requested the defendant to part of the contract, but on 15/2/2005, she refused to exclude the selling in the government. 15 फरवरी 2005 को हमको इन्होंने रिफ्यूज किया.
He refers to paragraph 19
20
and 20 of the plaint to submit that the refusal was on 15
फरवरी 2005.
to 2005.
अब हमने सूट फाइल किया.
Suit was filed on
22/3/2025. इमीडिएटली तो रिफ्यूजल हमें इन्होंने
2005 22/3/2005.
22/3/2005 पैकेज एविडेंस भी हम भी लाए हैं इसमें देखा जाए. पारा 7 में जो हमने कहा यह कि मैं कई बार मैं और मेरे पति प्रेमलता पांडे के घर में जाकर रजिस्ट्री के लिए गए. तब प्रतिवादी ने भू अनुबंधी अधिनियम के धारा 26 के अंतर्गत अनापत्ति प्रमाण पत्र के लिए आवेदन दिया जिसका नंबर सच है इसे पर्दा चांदी किया. यह कि भू अनुबंधी के 60 दिन समाप्त होने के बाद रजिस्ट्री में आनाकानी की प्रतिवादी तब हम और सोनिया देवी अपने पति के साथ उज्जवल पार्क के चैम्बर न्यूगाड़ा में बैठ के वकील साहब के कहने के अनुसार नोटिस दिए. 24/6/2004 को वकालतता नोटिस पृष्ठ में जिसका चौथा पृष्ठ पर हम हस्ताक्षर किए एवं वकील साहब ने हस्ताक्षर किए. मैं इसे पहचानता दोनों हस्ताक्षर और नोटिस को अंसद नोटिस का वो बहुत कॉपी. इसका क्रॉस एग्जामिनेशन इन्होंने किया. तो क्या क्रॉस एग्जामिनेशन किया हम पढ़ बात पुकारा गया. पुकार पर प्रतिपक्षण हेतु प्रतिवादी के विधान उपभोक्ता उपस्थित नहीं तो कुछ किया ही नहीं. तो हम इसमें मेरा सब तो एडमिट है प्रतिवादी
Yes,
की ओर से कई
referred
विधियों
to
की पैरवी
the-
नहीं की जा रही।
The learned counsel has referred to paragraph 8 of the examination in chief,
7
para 7 and 8 of the examination in chief of PW1, and has submitted that
PW6
PW6, and has submitted that this witness has not been cross-examined.
लोग अपियर ही नहीं, बात पुकारा गया और बात पुकारने पर प्रतिपक्षण हेतु प्रतिवादी के विधान अवस्था
अरे भाई नहीं appear हुए ना, cross-examine नहीं हुए, they did not appear to cross-examine this witness, and therefore the entire evidence of PW6 remained intact. Bas
it appears there is some it should be PW5 but
PW5 PW5 was plaintiff number 1,
yes
plaintiff number 1 मीना देवी, है ना, PW5.
उसके बाद फिर इसका देखा जाए PW8
PW उसका पैरा नंबर बताइए. PW8 is who?
ये इसके हस्बैंड धर्मेंद्र विश्वकर्मा जो पैसा दिया था
पैरा नंबर बताइए.
बता 12 नंबर बुजुर्ग इसमें देखा जाएगा 9 इस प्रकार प्रतिवादी सब इससे पहले पारा में ही बता रहे हैं कि 15,000 इस तारीख को हम भुगतान कर चुके। तत्पश्चात प्रतिवादी ने मेरे समझ करारनामा इतना बनाया। इस प्रकार वादीगण ने प्रतिवादी को बतौर एग्रीम 55,000 रुपया भुगतान कर चुके। वादीगण की ओर से मैंने भी कई बार रुपया बकाया लेकर विवादित जमीन का निष्पादन एवं अनुपालन करके कहा, परंतु कोई न कोई बहाना करते हुए टाल मटोल करती है। प्रतिवादी ने विवादित जमीन को प्रतिवादी के पक्ष में बिक्री करने के लिए शहरी भूबंदी अधिनियम की धारा 26 की अनुमति प्राप्त करने हेतु एसडीएम रांची के न्यायालय में दायर किया एवं उक्त वाद में दिनांक 22/1 को अनुमति प्राप्त होने के बाद अधिगण के पक्ष में विक्रय पत्र का निष्पादन एवं निबंधन करने का बार बार अनुरोध करने पर भी टाल मटोल करती रही एवं लगातार यही आश्वासन देती रही कि है तो चिंता करने की कोई आवश्यकता नहीं। वादीगण ने अपने अधिवक्ता के माध्यम से 26/4/2004 को प्रतिवादी को नोटिस किया।
ये कौन सा पैराग्राफ 9 के अलावा क्या पढ़े हैं? उसके अलावा भी कुछ 9 एंड जो चीज वहाँ बोल चुके हैं उसको दोबारा यहाँ बोलने की जरूरत नहीं है। पैरा 9 एंड
पैरा 10 पैरा 11 पैरा 12 और पैरा 20
क्रॉस
विकार वाला एस्पेक्ट है।
क्रॉस
ये सब इस पे आगे भी लिखे हैं कि हम इकरारनामा के शर्तों का अनुपालन करने के लिए भुगतान करने के लिए हमेशा तैयार 14 अभी भी तैयार है। प्रतिवादी के इकरारों का अनुपालन नहीं किया और लगातार अनुरोध करने के बाद भी बकाया रकम लेकर के उसका निष्पादन नहीं किया। ये सब 14-15 में बोला और ये भी इसके बाद ये आया है कि 34/2003 दाखिल किए और दाखिल करने के में ये बात लिखे हैं कि मैं इनका कभी किराएदार नहीं हूँ। 12-20 में लिखे हैं। ये भी ये लिखे हैं कि
मिस्टर शर्मा ऐसे आप पूरा एविडेंस नहीं पढ़ सकते हैं। आप हमको बताइए कौन सा स्पेसिफिक एविडेंस है? ऐसे थोड़ी होता है। You have to specifically see.
पारा 9 में हमने कितना कंसिडरेशन टोटल पे किया?
55,000 दे चुके।
55,000 दे चुके। उसके बाद 10, 11, 12, 13, 14 ये सारे में हमने
55,000 रुपए कंसिडरेशन किसने पेमेंट किया है? आपने?
दोनों मिला
ऐसा कैसे लिखा? कहाँ लिखे हैं? दोनों मिला के किए हैं? क्या किए हैं?
नहीं, लेकिन वो 16,000 पे उसमें जोड़ने से तो 55 आ ही था। 40 में 16 जोड़ा था 55 आ जाएगा। 55 टोटल इनको मिल चुका है, 100 ही लिखा है। इसके बाद 12, 13, 14 ये सब में हमने हमेशा कहा है 13-14 पारा में कि हम गए थे, तो बल्कि इसके बारे में भी हमने कहा है कि हम इनका किराएदार नहीं। ये सब केस वाला भी आया है क्योंकि हमारे खिलाफ भी केस किए थे।
The learned counsel for the appellant has referred to the evidence of PW8 and has submitted that in paragraph 9 of his evidence in chief, he has stated that out of the total consideration 55,000 was already paid, and at the insistence of the plaintiffs, an application was filed for taking permission for sale of land, and even after getting permission, the defendant was approached time and again, but she did not execute the sale deed. He has further submitted that ultimately the eviction suit was filed, wherein a stand was taken that the plaintiff number 1 was not the tenant under the defendant.
क्रॉस एग्जामिनेशन इनका क्रॉस एग्जामिनेशन इनका क्रॉस एग्जामिनेशन में जो क्वेश्चंस जो है रेलेवेंट क्वेश्चंस वो ज़्यादातर एग्रीमेंट के बारे में करना है क्या कुछ नहीं किया
यही दोनों का एविडेंस है ना इम्पोर्टेंट।
और ये इनका क्रॉस एग्जामिनेशन तो बेहतर होगा यही पढ़ें लेकिन इसमें हमारा जहाँ तक कि अपना प्लीडिंग है उसमें हमने
आप प्लीडिंग पे वापस मत आइए।
हम प्लीडिंग एंड एविडेंस दोनों को खाली एक बार ये कर कि हमारा प्लीडिंग ये है कि हमने रेडीनेस एंड रेडीनेस बराबर शो किया और हम अपना एविडेंस भी दिखा रहे हैं और लास्ट वाला जो रिफ्यूजल डेट है वो 15 फरवरी 2005 का है उसके लाइट में ये टाइम बाट में
ठीक यस
First is Miller, the severability argument, Millers. I think the contract is not severable for the simple reason why I say so.
yes
The contract is for sale of entire 7 kathas of land to 2 persons. It is not identified who will get which portion. Lordships have already noted that the consideration is also common. Now my point is not the vendor, that is the defendant, had intended to sell 7 kathas as a whole. It is not anyone's case that she intended to sell piece and piece. I may not choose the contract to be executed, performed, because one party has backed out. I will not want, because these 2 kathas of land may be absolutely useless for me, even if it is not identified. So why should, as a landowner, I may not suffer and I may decide, therefore, incapable of being performed. My intention was to sell these 7 kathas of land, to whom it is irrespective. The plaintiff cannot say that please sell me 7 kathas of land, that was also not the intention. So I say, once the other party to the agreement has backed out and there is a transfer of agreement by whatever nature, whether it's right, wrong, there cannot be any performance of this contract. This contract has become incapable of performance because the intention was sale of 7 kathas. I think not I'm clear.
neither the area is segregated nor the consideration is segregated. Even in their entire plaint they do not segregate who has to pay
Correct.
what. Even in their evidence they do not segregate who has to pay what,
Right. Because if you
because they were moving together.
Now if a decree is passed today, sale deed for which identified piece of land, it is an undivided share my learned friend's client has. So that will, the court in a specific performance will not partition the property. So therefore it is absolutely. Moreover, as I go back,
And the intention also indicated a composite sale of
Yes.
the entire whole,
correct.
and that is why there is no segregation.
There no
of-
segregation. It was for them to, after they execute, get that partition done amongst themselves. My intention is dispose of my property. So today, if this 2 kathas is left and 5 kathas is given, it will be an absolute waste for me. So I want the 7 kathas or no less. Number 1. Number 2, specific performance. When we say readiness and willingness, it is not only said. Now the law is very clear. It is not only at the time of institution of the suit you have to say that I am ready and willing. You will have to show proof. What is willingness is that I am capable of paying or I am capable of arranging money. And that it has to also come in the evidence at a later point of time. This recent judgment of the Supreme Court makes it very clear. That is absolutely lacking in this suit.
Which is that?
Yes, I am giving it. This is 2019-17 SCC 429. 19-17 SCC 429, para 6.
What is the date of this suit? Suit was filed when?
2005.
22nd.
But this law is not fairly settled by.
Which paragraph are you?
Para 6 can come. In order to obtain a decree for specific performance, the plaintiff has to prove his readiness and willingness to perform his part of the contract, and readiness and willingness has to be shown throughout and has to be established by the plaintiff. In the case at hand, though the respondent plaintiff has filed the suit for specific performance on 29/4/2008, the respondent plaintiff has not shown his capacity to pay the balance consideration of rupees 22 lakhs, 2,20,000, 22 lakhs, sorry. In his evidence, the respondent plaintiff has stated that he has borrowed the amount from his friends and kept the money to pay the balance at present. As rightly pointed out by the trial court, the respondent plaintiff could not produce any document to show that he had an amount of rupees 22 lakhs with him on the relevant date, nor was he able to name the friends from whom he had raised the money or was able to raise the money. Furthermore, as rightly pointed out by the trial court, the respondent plaintiff could have placed on record his account books, passbook, or a statement of the accounts or any other negotiable instrument to establish that he had the money with him at the relevant point of time to perform his part of the contract. We are therefore in agreement with the view taken by the trial court that the respondent plaintiff has not been able to prove his readiness and willingness. Now another judgment is this 2023-11. 2023-11 SCC 775, para 45. Now this is what is important. It is set in law that for relief of specific performance, the plaintiff has to prove that all along until the final decision of the suit, he was ready and willing to perform his part of the contract. It is the bounden duty of the plaintiff to prove his readiness and willingness by adducing evidence. This crucial facet has to be determined by considering all circumstances, including availability of funds, and mere statement of government complaint of readiness and willingness would not suffice. Now, in this case, the plaintiff has not come in the witness box and said that I have the funds. The husband of the plaintiff has come and said.
Plaintiff has come. Meena Devi hasn't come.
She has come, but she has not said that I have the funds. PW6 does not say that I have the funds. The husband of the plaintiff says that we have the funds. So this is for the plaintiff to prove, not the husband of the plaintiff to prove. He may have funds because this is not a benami transaction that cannot be approved by the court. If someone else will sponsor and or she.
Has the husband said that he has the fund?
No, he has also said I am ready to perform. He's also said I am ready to perform, not the funds. So that's what I'm saying. Merely by saying that I will pay is not sufficient. You will have to produce some evidence, bank, passbook, some kind of funds to show at the time of evidence. In absence of that, there cannot be any decree for specific.
Severable is the main thing.
I think no. But my learned friend is not answered the intention. In any contract, what is important is the intention of the parties. The intention was to transfer 7 katthas of land as one parcel, not as separate parcels. That should be sufficient.
The learned counsel for the respondents.
Reply, I would like to see.
The learned counsel for the respondent has submitted that on the face of the agreement, it is not severable. Although the property was to be transferred to 2 different persons, and the area with respect to each one of them was mentioned, but no boundary was mentioned, which itself indicates that the entire property of 7 kattha as a whole was to be transferred. He has also submitted that there is neither any reading nor any evidence as to how much amount of consideration was to be paid by each one of them. And the learned counsel has submitted that both the persons were fighting the suit together, and therefore, and there was only evidence that 55,000 was paid in connection with the property, but there was no evidence as to how much amount was to be paid, remaining amount was to be paid by either of them. He has submitted that in such circumstances, the agreement is incapable of performance qua the appellant.
Yes.
He has further submitted that there is no readiness and willingness to perform the part of the contract on the behalf of the applicant when seen in light of the provision of section 16 within bracket 1C. 1C, है ना?
Yes.
16(1)(c) of the Specific Relief Act. For that purpose, he has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2019, bracket close 17, SCC 429, para 6, bracket 2023, bracket close 11, SCC 775, para 45. The learned counsel submits that since the agreement was not severable, the remaining questions also fall in place,
Yes.
and therefore no relief can be granted to the applicant. आपको क्या बोलना?
In reply, I would like to say, from the agreement itself, 5 kattha and 5 kathas and 3.5 chatak is very much.
No, we have noted it. आपने तो calculation भी अभी करके कंप्यूटर से calculator से
सेपरेशन का जहाँ तक का बात है, और इंटेंशन का अगर बात है, अगर इंटेंशन अगर दोनों का अलग अगर एरिया मेजर्ड नहीं तो साढ़े क्या जरूरत था 5.5 और 5.5
बाउंड्री भी नहीं,
बाउंड्री तो एक है
नहीं बाउंड्री भी नहीं है, किसको कौन सा बाउंड्री किसके नाम से जाए?
7.5 कट्ठा का अगर प्लॉट है
7.5 कट्ठा का कौन से पोर्शन का सेल डीड आपके नाम से करते हैं? कौन से बाउंड्री का सेल डीड आपके नाम
हम
से
तो
करते
अपने पोजीशन में है, और एज पर माय इंस्ट्रक्शन जो 2 कट्ठा वाला जो सेल ही किए हैं वो भी ऑलरेडी पोजीशन है, तो उसमें कोई अगर इसमें कोई डिस्प्यूट नहीं है। अब रह गया जहाँ तक कि कंसिडरेशन मनी देने की बात है या हमें पेमेंट करने की ताकत की बात है, तो हमने तो 55,000 रुपया ऑलरेडी पेड किया है, दैट इज ऑन रिकॉर्ड। तो बाकी बच क्या रहा है 20,000 रुपया, उसमें मेरा ज़्यादा से ज़्यादा होगा 10-12-15,000 रुपये मेरा। हम तो मेजर पोर्शन ऑफ द कंसिडरेशन आई हैव ऑलरेडी पेड, एंड देयर आफ्टर नॉट ओनली दैट, देयर आफ्टर आई एम इन पोजीशन। उसमें सुप्रीम कोर्ट वाला जजमेंट हम देते हैं।
नहीं हमको पता है वो
हम
जज, अगर मेजर पोर्शन आ गया है तो इसमें बहुत ज़्यादा
उस केस में एक केस में हमने बात भी किया था, उसने रिलाई किया। So far as the readiness and willingness, yes, your lordship is concerned, उसमें readiness and willingness का जो aspect है that we have pleaded, we have proved, and so far as the judgments which my learned friend is relying on, I have no dispute with relate to with the proposition, but these judgments will not apply in my case, in my case. I was always reading and willing, और इन्होंने परमिशन भी इन्होंने लिया जब हम 2004 का जब हमने नोटिस इशू किया, उसका ये कोई आज तक जवाब नहीं दिए। क्रॉस एग्जामिनेशन में भी आकर के ये नहीं अपीयर किए। दिस आल्सो इज शोस हिज कंडक्ट।
The learned counsel for the appellant has submitted that upon the appellant being in possession of her portion of the property, the properties to duly identified. He has further submitted that the readiness and willingness has been duly proved in as much as there is no cross-examination on the part of the defendant from the side of the defendant in connection with the statement made by the witnesses regarding readiness and willingness to perform their part of contract. He has also submitted that though the proposition of law laid down by the Honorable Supreme Court in the judgment cited by the respondents is not in dispute, but the same do not apply to the facts and circumstances.
While your lordship considers our submissions, we will have a regard to the schedule of the agreement and the boundaries. It is one parcel of land which is the schedule.
I've seen that. This appeal is dismissed. I will go and dictate the judgment letter. Orders.
Orders item 9, second appeal 531 of 2017.
What is this for?
for paper publications notes.
IA number?
Number 8735 of 2025.
IA number 8735 of 2025. The learned counsel.
8735.
Sorry?
8735.
873 of 35 of 2025 in SC number 531 of 2017. This petition has been filed for substituted service of notice upon respondent number 21 to 24, 28 and 29 and 32 to 34 and 17 through newspaper publication. He submits that these respondents are residing in, where are they residing?
They resides in the Putti.
In the district of Putti. All of them? All of them?
No, some are in Jamshedpur, East City.
तो दोनों का अलग अलग करेंगे, कैसे करेंगे?
Circulation को पूरे
He submits that they are all residents of Jharkhand. He also submitted that in spite of best of efforts, the notices could not be served upon them. Considering the aforesaid submissions, the interlocutory application seeking substituted service of notice is accepted, is allowed, and let the substituted service of notice through newspaper be published. In a newspaper Prabhat Khabar and Telegraph, having circulation in Jharkhand. The appellant is directed to, the counsel for the appellant is directed to submit draft notice to be published. The registry is directed to go through the same and hand it over to the,
only one paper.
go through the same and after being satisfied, hand it over to the counsel for the appellant for publication.
Minutes, only one lead paper will serve the purpose minutes.
Can't be this. Two newspapers. It has to be two newspapers. English, Hindi, don't know. Post this case on the supplementary affidavit annexing the newspapers. Cutting mat लगाइएगा, paper लगाइएगा. Be filed before this court by the 10th of October. Post this case on fixing the date for appearance on 10th of October. The newspaper publication be filed in original by 10th of October.
Another prayer minutes.
एक हफ्ता में आप डाल दीजिए.
Yes, I will do that.
बोलिए.
One thing minutes, the respondent number 15, 25, 26, 36 has been reported that they died, but the appellants served and found that they are alive minutes. So I pray to this court
उसके लिए आपको आईए फाइल करना पड़ेगा. आईए फाइल करना पड़ेगा.
and another one minutes, the respondent number 38, the summon of 38 received by grandson and 45.
आने दीजिए उसे सबमिट करेंगे. एक सब्स्टिट्यूट
by
सर्विस
letter,
आएगा
so
उसी
it may be treated as validly served.
उसी दिन होगा ना. ये पार्टीशंस होते हैं. कौन सा सूट है?
Titles.
ठीक उसी दिन करेंगे. और ऑर्डर्स देखिए.
Item 10, second appeal 278 of 2018.
Yes, appellant.
On the previous day, direction report had come that the respondent had sold the property and have moved to a different place. We had already issued a lot of notices from the respondents to both modes, and then direction was issued by a petition to file a appropriate petition for substituted service of notice we had filed the IA for substituted service of notice, and however, in the order it also came that we had to file notices by way of registered speed post, for which we later on filed these notices for registered speed post. All I was saying,
There is already an order. 8747. This is for paper publication.
this is for paper publication.
Yes, what else?
Yes, I was saying that on
In view of order dated 3/7/2025, requisite for notice not filed within 10 days. So,
So on 3rd July, I had prayed for substituted service of notice.
which, by virtue of which order?
3rd July,
3rd July.
order number 9. So later on, we filed the registered speed post requisites also. But we filed
और
this-
तो है ना?
Yes,
आपने कब फाइल किया?
we filed the IA for paper publication within time.
वो विदिन टाइम हो
Within
गया ना? ठीक है, वो कोई DFD नहीं हुआ। कोई DFD का नोटिस किया भी नहीं। IA number 8747 of 2025 in essay number 278 of 2018. The learned counsel for the applicant has submitted that in spite of best of efforts, the notice could not be served upon respondent number 1, 2 and 3 who were lastly residing at
The local address was Jamshedpur, present resident of Vadodara.
I don't know how do you, if you
I
have
have
the
filed-
present residence then
I
you
have-
have to take steps at the
I've
present
taken
and
all
correct
steps on
address.
I've taken steps on the present current address that the appellant is in order. We filed the IA for paper publication in Vadodara, which is in memo.
So you are aware of the present and correct address. Then why did you file your petition for
Because notices were not getting delivered at those addresses.
at Vadodara? You have sent notices at Vadodara.
Yes.
When did you send the notices at Vadodara? 17/10/24.
First of all, direction was on 19/7/23. We had issued notices by both.
You have been
processes.
sending notices at Vadodara.
In both the addresses.
Vadodara का एड्रेस है क्या? दोनों जगह पब्लिश कराइए। उनका प्रेजेंट एंड करेक्ट एड्रेस कहाँ का है? लास्ट नोन एड्रेस?
Vadodara.
नहीं, ये तो वडोदरा है। उसके पहले
Jamshedpur.
जमशेदपुर।
But it has come in the report that they have sold the property and left for Vadodara. In the SR report that has come after issuance from process.
दोनों जगह पे करना है। The learned counsel has submitted that in spite of best of effort, the notices could not be served upon respondent number 1, 2 and 3 at the address which has been provided in the memo of appeal as per the records, as they had left as in terms of office note, they had left for Vadodara. And therefore a petition for substituted service of notice has been filed. Considering the aforesaid submission, let the notice be served upon respondent number 1, 2 and 3 through substituted service of notice through newspaper. वडोदरा में कौन सा होगा? टाइम्स ऑफ इंडिया। टाइम्स ऑफ इंडिया वडोदरा में तो कोई हिंदी समझेंगे ना? थ्रू हिंदी कौन सा न्यूज़पेपर होता है? मुझको तो खाली प्रमोट करो नेशनल रैली ना मारो
We
टाइम
file the Sanman
in Times of India having circulation at Vadodara and in Prabhat Khabar and Telegraph having circulation at जमशेदपुर ठीक है बाकी जो टाइमलाइन दी है आप फाइल कर दीजिए नोटिस इट विल कम ऑन कौन सा डेट दिए थे पंकज दूसरा केस में
10th October.
10th October it will come. You'll have to file the paper publication by. So it will come on 10th of November. Paper publication file करने का कब तक करना है?
Fixing the date of appearance on 10th
Appearance date appearance is 10th of October, but you have to file your 10th of November ना? कौन सा डेट दी? Appearance के लिए 10th of November. 10th October. 10th October तो see you have to file your paper publication by 10th of October, okay, by supplementary affidavit, but the date for appearance is 10th of November. न्यूज़पेपर में डेट ऑफ अपीयरेंस रहेगा तो एक महीना का गैप दे रहे हैं यू गेट इट इवन दे हैव टू मेक अरेंजमेंट्स एडवोकेट अरेंज करना है कुछ करना है ठीक है इसीलिए एक महीना का गैप
But the 10th of November date would be then fixed by the
fixed by the office. They will fix the date for appearance on 10th of November. But you have to file your paper publication by 10th of November. This is what I meant in the earlier order also. I will correct it.